The self-regulatory landscape for advertising is one which is constantly changing, and not least to keep up with digital advances. As forms of media converge, this brings new challenges and opportunities for advertisers. The two areas that we will cover here are online behavioural advertising, or OBA, and the use of children as brand ambassadors in peer-to-peer marketing. Of course, the concept of behavioural advertising is nothing new. Arguably, it is one of the best forms of advertising, allowing advertisers to target their products and sales messages to those consumers who have purchased or shown an interest in similar or complementary products. However, there is clearly a marked difference between your local shopkeeper using his knowledge of what you like to buy by suggesting new or alternative products, and the case of a third party who is collecting and using your online behaviour. The use of OBA has recently come under the remit of the Committee of Advertising Practice through dint of the CAP code. As with the general rules and other methods of delivering advertising, the OBA rules are administered by the Advertising Standards Authority. The CAP code provides that consumers must be aware and have the opportunity to exercise control over the collection and use of information for the purposes of OBA. Third parties such as advertising networks, delivering advertising using online behaviour data, must do a number of things. Firstly, they must give a clear and comprehensive notice about the data they are collecting and what it is being used for. This needs to be in or around the display advertisement delivered using OBA. They must also include how a web user can opt out of this, and that notice should link them to the place that they can do this. Thirdly, it is important not to create so-called interest segments which are specifically designed for the purpose of targeting OBA to children. And for these purposes, children means 12 or under. So, to emphasise, the key here is that a web user must receive a clear message about the data that is being collected and what it will be used for. Also, the opt-out mechanism must not be more than 2 clicks away from the advertisement. As part of its new remit, CAP wrote to a number of third parties whose websites it considered were likely to breach the CAP code. This was by way of an informal process designed to bring these specific provisions of the CAP code to the attention of the third parties and alerting them to why their websites might be in breach. The third parties were asked to make the appropriate alterations in order to bring their websites in line with the new rules. Now, although the new rules apply only to third parties, such as I've said, advertising networks, in cases where the Advertising Standards Authority is unable to identify a third party, the advertiser, that is, the advertiser on behalf of whom the OBA advertisement is delivered, must, in good faith, cooperate with the ASA in helping it determine the third party's identity. We must expect further developments in this area as the new rules get bedded in, and perhaps as we see a number of cases proceed to formal adjudication by the Advertising Standards Authority. In addition, although the rules do not currently cover OBA on mobile devices, and this is important, the CAP has announced that it is likely that they will do so in the future. The inclusion of mobile devices will necessitate an updating of these rules.
An issue through advertising online is where advertisers ask children to endorse a product in return for virtual benefits, such as access to exclusive content or a promotion. If you are an advertiser, there are rules in the CAP code that you must comply with to ensure that the use of children in peer-to-peer marketing and as brand ambassadors is undertaken responsibly. You must clearly identify any marketing material that you use on social media. You can do this by using text such as #spon, sponsored, #ad or advertisement. To make your marketing material transparent, you must make sure that children know what is required by them. For example, asking them to retweet or to share his or her commitment to a product or a brand. Never say a child must do something. You mustn't put them under undue pressure or make them feel inferior or unpopular for not owning a product or liking a particular brand. You must not do anything to encourage peer pressure to engage with marketing. For example, that a child should only have friends who have liked product X. Being socially responsible means about thinking how a child might react, bearing in mind the target age, loyalty, vulnerability, experience and the context of the advertisement. You should never ask a child to add strangers to their social networking profile in order to qualify for a promotion. Pester power is an issue. Children should not be encouraged to pester their parents to buy a product. Do not use phrases such as "get this product now" or "get your parents to buy this for you." If you're a member of the Advertising Association, you will need to make sure that you are aware of their best practice principles on the use of under-16s in brand ambassador and peer-to-peer marketing.